Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he's joining us on the Ag Issues program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
All right, let's get right to it. One of the things that two of the things we want to talk about, and let's get right to it, in front of the U.S. Supreme Court. And let's start with the California Proposition 12 case. And let's just start, first off, just a quick recap on the matter. And after the arguments were made last week, oral arguments were made last week, where do we stand right now?
Well, California passed a law a few years ago. It's known as Proposition 12, and that says you can't sell pork products in the state of California if the seller knows or should know that the meat came from the offspring of a sow that was confined, as they said in their statute, in a cruel manner. And so that means, among other things, that sows must have at least 24 square feet of living space. Well, we all know that farming practices in the Midwest and in the Plain States where there is pork production, that's the way that sows are caged during the birthing process. And so that removes the California market for a lot of the producers in the pork-producing states. And that's the problem. And that's why we have the case at the Supreme Court. The constitutional connection is based on the Commerce Clause, and more specifically the Dormant Commerce Clause, if there is such a thing, which arguably prevents one state from dictating the production methods occurring in another state.
So the arguments that MPPC and AFBF attorneys made, what were those specific arguments? And then I guess more importantly, how did the justices react to those arguments?
Well, the argument for the producer's attorney was that states cannot condition in-state sales on requiring out-of-state businesses to operate in a certain way. And that's what Proposition 12, and so therefore they said, per se, that's unconstitutional. The court simply was not buying that at all. I would not want to have been the attorney, particularly Mr. Bishop, arguing the case before the Supreme Court. He absolutely got destroyed by the justices. And it was difficult to sit at my desk and listen to that and just cringe to his responses, cringe with his responses to the justices. The justices, many of them, well, let me take a couple of them first. Justice Thomas doesn't talk very much on the court, doesn't question attorneys very much. He asked one question, and that was, Counselor, can't this be handled by federal legislation? Well, the answer is yes. In fact, I was one of the individuals that drafted the provision for the 2014 Farm Bill that it would have removed this possibility. We never would have had this case, but that got dropped out at the last minute, saying states can't do this kind of stuff with respect to agricultural products. So the answer to that is yes, and the attorney responded that yes, Justice Thomas, it could be dealt with by congressional legislation. So Thomas, we can kind of scratch off. He's not going to. He's going to kick this to the Congress. Now, keep in mind, this case is on a motion to dismiss. There's never been a trial on the merits. Even out in California, as it worked its way through the court system and through the Ninth Circuit, there was never a trial on the merits. So this is on a motion to dismiss, and the Ninth Circuit dismissed the case. And so that's what the appeal was, and that's what the Supreme Court is discussing here, and that's what the issue is, whether they send it back to the Ninth Circuit for a trial. Now, Judge Kagan as well as Judge Barrett and Justice Sotomayor, they're all together on this, saying that we don't want the states at each other's throats. We don't want these disputes ending up in a balkanized nation, as what they said. Because, I used an example in a television interview on Monday, the day before the court case came out, saying, well, what if Iowa, that doesn't produce any almonds, comes up with a rule that says, we like trees. And so California, unless your almonds are hand harvested, and they aren't, they're shaken by a machine, it's a tree shaker, we don't want those tree shakers shaking the almonds off the trees because they might harm the trees. And so unless you can prove that all those almonds were hand harvested, you can't sell into Iowa. And of course, Iowa doesn't produce any almonds. California has 100% of the almond production in this country. The out-of-state effect of that Iowa law would be 100% borne by California. And so the justices were concerned about states retaliating. Justice Barrett, in particular, said that there must be many state laws that would impermissibly regulate out-of-state businesses under your rule, according to the producer's attorney. And the Deputy Solicitor General also in favor of striking down the California law, which is interesting, representing the Biden administration, but now in this case on the side of the pork producers, tried to reassure her that striking down Proposition 12 would not have a broader ripple effect. But the justices didn't buy that argument at all. I think there's a majority of them that don't buy that argument. Justice Jackson is trying to thread the needle here. Now, this is interesting, and I think this is important in a broader sense for agriculture. And she said, to what extent does California get to control how Iowa houses its sows? That's a great question. Why can't California, she went on to say, solve this problem some other way? Now, this is the key point, and this opened a door here that I don't think a lot in agriculture thought about, but it's something I've been saying for a number of years. She went on to say, why can't they just segregate Iowa's pork or require it to be labeled as coming from conditions to which the state objects? Put labels on the stuff and say, all right, this pork was raised in a manner that California deems to be inhumane. If you don't want to buy it, don't buy it. This pork product sitting next to it on the shelf was raised in accordance with California's, quote, morals, end quote. Therefore, it has a higher price to it, but feel free to buy it. But everybody's got access to the market that way. More information to the consumer, a number of the justices was saying, would solve this problem. So bottom line, Greg, on this one is I don't think this case is over. I think it survives a motion to dismiss. And I do think the opinion will be written by Justice Kagan. And Justice Kagan is the one that offered that as a possible solution to the dilemma that the court was facing. She noted that the dispute came to the court before there was a trial on the merits. So what she's saying is that at this point in the litigation, the court should just accept the pork producers' allegations in their complaint as true and kick it back to the Ninth Circuit for a trial on the merits to see if California's moral interests in the law are something that the court should consider. And there are great costs to the pork industry in this, and those are the costs on the other side. So I think at the end of the day, we see an opinion by Kagan. The court reverses the Ninth Circuit, kicks it back to the Ninth Circuit for an actual trial on the merits, and probably about 2 years from now, this is back to the U.S. Supreme Court unless Congress deals with the issue, and I don't suspect that they will.
Short term on that, when would you expect, or what's your prognostication as to when you would think an opinion from the Supreme Court would come out on this?
Oh, probably about January. That'd be my guess. I don't think it's going to take them long. In fact, I think they met in conference right after oral argument, and they know what the decision is. Now it's just down to who writes it. I think Kagan probably writes it, and I anticipate that, as I said, I think they'll say, well, this is not really ready for us to hear yet. Let's let the pork producers have their day in court. They haven't had that yet. And so I think probably about January we get an opinion in this one, and that's what I expect it to be.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And Roger, that is one case talking about Prop 12. The other case is concerning Sackett versus EPA, the case from up in Idaho. And a quick recap of what this case is all about.
Yeah, Greg, we're in the 15th year of litigation in this case. God bless the Sacketts. The EPA has just created a nightmare of a life for them. All they did was they bought a 0.6 of an acre lot in 2004 up on close to Priest Lake, which is in the panhandle of northern Idaho, not too far from Canada. Absolutely spectacular area. I'm going to have one of my summer conferences out near that area next summer. But they are separated from the lake, and the lake is a navigable water. It runs for a number of miles, and again, a very beautiful area. But they are separated by a road and a row of houses, and it's well over 100 yards from their little lot to the lake. But the EPA determined that they have a wetland, started fining them. $40,000 per day was the penalty for backfill sand and gravel on the lot. They ended up in the Supreme Court on the initial case because the government came in and said, well, that's a wetland, and the Sackett said, well, there's been no determination. Make a final determination. No, we just think they're wetlands. That went back and forth, got to the U.S. Supreme Court, and the U.S. Supreme Court unanimously told the EPA that you need to make a final determination so that they have something from which they can appeal. So the case went back. EPA made a final determination, said you've got a wetland because you don't have to have a direct connection to the lake. You can connect to something that connects to something else that flows into something else that gets to the lake. This joint is connected to that, and that is connected to that kind of argument. And so that's how the case got back to the U.S. Supreme Court. And so the issue is, what is a significant nexus? The Sacketts are arguing you have to have a direct connection. And that is kind of like Justice Scalia's position that he took in the famous case a number of years ago in Rapanos in that decision. And that decision really had about 3 or 4 different decisions within it. And so the courts have struggled since then in determining, well, what is the test for determining whether an area is sufficiently connected to a navigable water of the United States such that it is a wetland subject to EPA regulation. Of course, the EPA is arguing, well, separation doesn't matter. Separation distance doesn't matter. As long as you've got connection all the way through, that's enough. So this is the whole question before the court, Greg, and that is, what is a significant nexus? And the justices are split on this. They were clearly split in their questioning of the attorneys. Kavanaugh noted that for about a half century, since the 70s, the EPA has made it clear that wetlands can qualify for coverage under the Clean Water Act, even if they're separated from navigable waters by barriers. And whether those barriers are man-made or whether they're natural doesn't matter. And he was asking the Sackett's attorney whether that shouldn't continue to apply. Roberts basically said, and I think his point resonated with some of the other justices, that the water doesn't have to flow continuously from a wetland to a larger body of water for the act to apply. And so therefore, he's asking, well, how much of a connection does there have to be? And Gorsuch pointed that out. He said, look, this property is separated from the lake by a road and a row of houses. So how is a landowner supposed to know whether the property is close enough to a navigable body of water that the permit requirements of the Clean Water Act apply? And so the justices are all over the board on this. And Kavanaugh and Thomas basically said, look, this is up to Congress. Congress needs to clarify this. They need to amend the Clean Water Act to come up with a statutory definition so landowners know. Now, this is also back in the administrative agency right now. They're trying to write a new rule. If you remember back in the Trump administration, the rule under the Trump administration really removed this potential problem. The rule that they came up with redefined the Obama rule to include only traditional navigable waters and perennial or intermittent tributaries that contribute surface water flow to the water. So you had to have a direct connection. Well, the Biden administration came in and they removed that rule. They're trying to figure out what the path forward is. And in fact, they told the court, well, we're working on a rule to try to clarify this. And the court didn't seem to be too amused about that. So I don't know how this one comes out. Kind of on the bottom line, the justices are all over the place on this. I do think they will probably come up with a different rule. And we'll see if the administrative agency gets their rulemaking done before the Supreme Court. We're just in a really bad position on this right now, where it's in the court, the agency's trying to write a new rule. Nobody knows what the rule is actually going to be, but yet the program is trying to be administered. It's an absolute disaster right now.
Going back to the point of it being decided by Congress, I mean, hell, how many, from the time from the Obama administration onward, that it's been tied up in litigation of some sort through now, almost 3 different versions of the rule.
Yeah.
And yet, here we go. We're still in so much limbo.
Yeah. Yeah, Greg, I have a footnote in the environmental law chapter of my ag law treatise that tries to encapsulate all the court cases where the courts have tried to figure out what the rule is. And that footnote takes up 3 pages. And my footnotes are in 9-point Times Roman font, that small. And it's 3 pages of a footnote. That's how messy this is, trying to categorize all of these cases, all of this litigation. And it's just a nightmare for landowners like the Sacketts. You buy a lot, it's a dry lot, it's not connected to the lake, or so you think. You have no idea that the feds might assert jurisdiction, and now you're in what's pretty close now to the 16th year of litigation on this. What a nightmare.
Well, it's safe to say I'm sure we will have discussions on both of these down the road, Roger.
Probably we will.
All right. Hey, Roger, I appreciate it. Appreciate your patience, and appreciate you, as always, joining us on the program this morning.
Thank you, Greg. My pleasure.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.